So we are recording. Can everyone see the PowerPoint? Okay, great. So let's get started. I'm Sasha Harnden with the Inner City Law Center. I'm a public policy advocate. I'm a former Capitol lobbyist. A few weeks ago, I transitioned back to Los Angeles. I'm still working on state legislation as well as city and county policy. But I was with the Western Center on Law and Poverty, which is one of the strong groups representing tenants up in the Capitol. And so I've done a lot of these meetings. I'm by no means sort of have all of the answers. There's a lot of ways to do this. Lobbying is weird. It's very sort of squishy and relational. So I think what we'll do is probably hold questions till the end. And folks should feel free to jump in at that point and also share their experiences doing this. I know we have a lot of powerful advocates joining us today. So please feel free to share your expertise as well. Natalie Medina with the Eviction Defense Network is also with us today. She's going to be helping out and sharing part of the presentation around some of the background for AB 1436. So we'll start with just sort of general considerations for any lobby visit. This isn't obviously specific to this bill that we're talking about today. I was asking my mom, who's done this like 1 or 2 times, you know, what did you want to know that nobody told you going in? And I'm glad that I did that because she pointed out that the first thing was just sort of how to address people, what the protocols are. This is a lot more relevant when you're doing this in person because sometimes it feels like a very official thing that you're doing in the Capitol in these, you know, old school buildings with wooden panels on the walls and stuff like that. It can be an intimidating experience, even for people who have done this a million times. But I think the key is to be confident. You have a right to talk to your legislators. They're your representatives. And so going into these meetings, I think it's just important to know, you know, they work for you. So you may, if you request a lobby meeting, you may end up meeting with the senator or the assembly member themselves, the actual legislator. Or often they'll be tied up, they have a million things going on, and you'll be meeting with their staff. The Capitol tends to be a pretty informal place. So I would say, you know, if you are meeting with the legislator themselves, it's good to address them by their title, senator, whatever, assembly member, whatever. With the staffers, it's usually just sort of a first name basis. In terms of just basic considerations, it's always good to start the meeting, you know, thanking the person for meeting with you, thanking them for their time. These are very busy people. And while that feels a little pro forma, it's always good to do. Don't forget to introduce yourself. I've done that a bunch of times because I'm excited to talk about a bill. Maybe I've been trying to meet with this person for a long time, and so I just sort of dive in. And also have a plan for your meeting. You know who it is that you're meeting with, whether there's anything sort of specific about their district that may be relevant to the bill that you're talking about. I did a lot of lobbying around housing bills after the fires, the big wildfires that we had in 2017 and 18. And so, you know, one of the things that I was always double checking was, is this a legislator whose district has been really hit hard by these fires? And do I need to speak to that when I'm talking about tenant protections or building affordable housing? It's always a good idea to know how they've voted on similar bills. There's a website called Leginfo that has sort of all of the history of various bills. It's the place where you can go to look at the text of a bill. I should have put in the link here and I forgot, but I will pop it into the chat towards the end. But that is a really useful resource because you can go there to see how this legislator voted in the past. So for example, if they voted yes on AB 1482, the Tenant Protection Act, sometimes I like to reference that when I'm sort of starting a meeting and say, you know, I know that your boss or you, Senator, have been really strong on protecting tenants. I know that you supported 1482, and we're here to talk about, you know, what you can do to help those people even more. Be direct. It can be an intimidating situation. It can be a little uncomfortable to sort of be asking somebody to vote yes on something, to be asking direct questions and sort of not letting them get away with, not really answering the question. Make sure that they do. The purpose of these meetings is to give information and to get information, and to communicate to this legislator why it's important that they do what you want. So don't let them get away with sort of, oh, I don't know, we'll talk about it. As much as you can, try to get a direct answer, even if that is, well, these are the things that I'm thinking about that would be, relevant to me recommending that the legislator vote yes. At the same time, we want to be respectful. We want to maintain that channel of communication. Part of lobbying is about building relationships. And we want to make sure that we have the ability to follow up with these people, to meet with them again. So we don't want to, be too aggressive and sort of alienate people. That doesn't mean not being direct or not, getting a straight answer. Really important to know who is in the room on both sides. Take notes about who you're meeting with, what their role is within that legislator's office. Are they in the district office? Are they in the Capitol office? Typically, a legislator will assign somebody to staff either a specific bill for them or a specific committee. So if a bill is going through the Judiciary Committee, there may be a particular staffer who's assigned to talk about those bills, to review them, and to make recommendations to the member. That might not be the person you're meeting with, and that's okay. It's just important to know that, to capture that information, so that if there is follow-up, if you do need to circle back, you can find out who the person staffing the bill is, and go directly to them. Part of what happens in a legislative office is typically staff will look at the bill first, they'll read it, they'll digest it. If they have questions, they will reach out to the bill sponsors or supporters of the bill, or the opposition, depending on who they sort of trust or want the information from. Once they've sort of figured out what their own recommendation is about the bill, they will typically brief the assembly member or the senator. And so it's important to find out whether or not that meeting has actually happened, where the legislator themselves has been given all the information about the bill and has had a chance to sort of say to their staff how they're going to vote. Because sometimes that hasn't happened yet. And so, we may not be asking at that point, how is your boss going to vote? We might instead be asking, how are you going to recommend that they vote? Or we might need to follow up once that briefing has happened, to really find out the concrete answer of what that vote is going to be. Important to explain who you are. Are you a sponsor of the bill? Are you a supporter? Are you opposed to a bill and you're asking for them to support some changes or to vote no? And what I mean by introducing yourself is not just your name and organization, but why that matters. Why should this person listen to you? Maybe more than they're listening to other folks like a landlord industry association. And what is your connection with the legislator? If you've had experiences working with them on another bill, if you've helped them get something passed, if you have, if you serve an important role, as many of you do within the district, it's important to say that to them so that they understand why they should listen to you, why you're relevant, and why they should ignore other people who are arguing against you. So this is just going to be a recurring theme. I think it's really important to be confident and to just remember why you are having this meeting. Why are you sitting in this room? Largely for residents, it's going to be about telling your own story, making the issues that we're talking about real for the legislator that you're meeting with. Many, many, many legislators are not renters, and many are actually landlords. And so specifically on housing bills, it's really important that they understand what the lived experience of tenants is. Those are people that they represent, and they need to really understand from your perspective why this problem is something that they should deal with when they have a million different subjects that they could be addressing. Why is this the one that rises to the top? Why is this the thing they need to care about the most? And then describe, once you've described that sort of the problem that you're there to address, describe the solution. That could mean a single bill, that could mean a set or a package of bills. And I think starting out the meeting, usually these meetings are maybe a half hour. If you're lucky, you'll get an hour. So it's really important to find out what information they already have they already reviewed the bill language, and to ask, I like to start meetings by just saying, how can I make this most useful for you? You might find that they've already studied the bill in great detail and they just need sort of your position and your points about why it's important to vote for. Other times they may not have even looked at it once. And so, you'll want to tailor your meeting in terms of what information you're providing, and also what information you need to bring back later. So ask the staffer if they have questions, if they can have concerns. Importantly though, don't answer questions that you can't answer. Don't guess. I don't know is a really good answer to a question. And the most important thing is to, if that does happen, is to commit to following up, to getting the information and getting it to them. If you do that, write that down and actually follow through. I've had the experience once or twice of lobbying on a bill and forgetting or not including when I send follow-up information, some basic fact that staffer could easily Google themselves. But sometimes if we don't do the follow-up, they will try to use us as the excuse for, oh, well, you never got me that follow-up information, that one number that I asked for, and that's why my boss, didn't end up voting on the bill or whatever. While that is BS, you don't want them to have that excuse. And so it's really important, if you do talk about following up, providing facts, statistics, whatever the case may be, that follow-through actually happens. The purpose of these meetings is to make the ask. And this might sound silly, but sometimes you get so caught up in sort of the back and forth discussion about the bill that you forget to actually say, we want you to vote yes, will you do that? So really clearly state what it is you're there for, what it is you're asking for. If there are concerns that come up during the meeting, take really detailed notes about those, because that will be helpful. Even if it's not you who's following up, capturing all of that feedback will be really helpful when the lobbyists in the Capitol, when the author's office are working to sort of figure out whether they have the votes for the bill to pass. It may feed into amendments that are made to the bill. Or it might be, that we need to sort of generate more information or go to certain groups to help also lend their support based on those specific concerns of either the staffer or the legislator. Ask the staff what their recommendation is going to be. If they say they don't know, I still need to study the bill, I'm thinking about it, I need to talk to other people, ask the follow-up question, what do you need to get to an I recommendation, to a yes vote? And again, ask when they'll be doing that briefing with the legislator, or the member is another term that we use for those folks, and when you can circle back to get a concrete answer about how that person's going to vote. I think I've covered most of this, but post-meeting, it can be really helpful to just sort of digest the meeting, do a little debrief with your team, figure out what went well. You might be doing multiple meetings, and so that those discussions can help you sort of sharpen your skills, sharpen your talking points, discuss with your team and capture all of the questions that were asked, whether those might indicate something about how that person's going to vote. And then do follow up and provide, whatever information they need, offered to be a resource. So if questions come up down the line about the bill, you want to be the person that they're coming back to and asking those questions of. You don't want them going to your landlord or somebody else. If you don't get an answer to a question or to your ask, always follow up and circle back once you've provided the information they need. A couple of just sort of key things not to do. I did have the experience before I was a lobbyist. I did one of these meetings and I got really prepared and I was really excited about the bill that I was talking about. It was super important. And I got really into sort of my plan for the meeting. And about halfway through, the member told us, basically, I'm going to vote yes on this. And we didn't really change our meeting. We just kind of kept making our pitch. And he gave me the advice he said, never talk past a yes, meaning if you already have the commitment from that legislator that they're going to vote, that might be the time to just say, thank you so much. Let us know how we can support you and sort of end the meeting there. If we keep talking, sometimes we'll end up saying something that actually raises a new concern for them. And we want them to be in that good place of feeling like, you know, we've all accomplished our goal. We're all in this together and we're all going to support this bill. Don't criticize the bill if you're asking them to vote for it, but do be realistic about sort of what it's going to do and what it's not going to do. We know we're in a housing crisis. We know that there are millions of vulnerable tenants. We were in a housing crisis before COVID. Now things are even worse. It's okay if the bill that you're asking them for won't solve all of the problems in the world. But it's good to always frame those limitations as another reason to vote for the bill. So what I mean by that is sometimes a legislator will ask, well, will this bill help, you know, this small group of tenants who might be in a very specific situation? And if the answer to that is no, that doesn't mean that you shouldn't support that bill, right? Tenants need support in this crisis. And, you know, I always like to say, well, it might not solve the entire problem, but it's going to solve a really important piece of the problem. And so we'd encourage you to vote for this bill and to keep going and to keep supporting tenants and to, you know, vote for other legislation that will solve the rest of the problem. Critically important, do not mention or promise any money that you've given to the legislator. That for them, that is an ethical violation. They basically can't vote for your bill if that happens because it's seen as buying a vote. And we don't want to make that mistake. And don't make promises you can't keep. So if you're not the sponsor of the bill, don't commit to, you know, making amendments to the bill or changing the bill in some way. What you can say is, you know, that's really helpful information. That's really helpful feedback that you're asking for this or that change. And we'll take that back to the sponsors or the author of the bill, who does have the power to make those changes. And again, I said this before, but don't just sort of guess or make up the answers if they have questions that you can't answer. Just tell them that you'll go find out and you can follow up with the right information. Okay, so that brings us to the bill that we're talking about, which is Assembly Bill 1436. I'm going to give just a quick overview, and then I think Natalie's going to jump in with some background on why this bill is so important. It is AB 1436 because it is an Assembly bill. It's authored by Assembly Member David Chu, but currently it's in the Senate. So a lot of you may be talking to senators. The sort of Assembly bill thing versus being in the Senate has been confusing for some of us, but anyway, it's in the Senate and it will eventually be coming back to the Assembly for some reasons related to sort of the procedure of how this bill has moved. Importantly, a lot of other legislators have signed on as either joint or co-authors. The distinction between those things doesn't really matter. I can never keep it straight, but what that means is that there's a lot of legislators that have already recognized this is a critically important piece of policy and they want to put their name on it. This is really the only bill that's in the legislature that has the power to give protections to tenants from eviction, from the tsunami, the tidal wave, the freight train coming at us of evictions once the Judicial Council's rule ends, if it passes. And so we need to make sure that it does pass. And I'm going to turn it over to Natalie to explain why that is.
Hi, everybody. My name is Natalie Medina, and I'm a staff attorney with the Eviction Defense Network. So many of you are not necessarily new to the housing world, but maybe some of you are. Don't know everybody on the call. But generally, there's been a housing crisis that has existed just prior to the pandemic. I think with Elena, we sort of identify it being around like 2016 is when the housing crisis really started. So before the pandemic, there were just a lot of people who were living paycheck to paycheck, who were not able to have savings, have money for other necessities. And what the pandemic has done is just, it's really highlighted how big of a problem we already had and how we really did not have any protections in place to deal with anything unexpected, especially of this magnitude. So a lot of people, a lot of tenants are in danger of facing eviction because they've lost work through no fault of their own because of stay-at-home orders and the effects of the pandemic on the economy. And there are many people who are on rent strike who have not been able to pay their rent for many months, right? I know tenants that have not paid their rent for 5 months. And what that means for tenants is that they may be facing an eviction and facing displacement and homelessness. So we really do need the legislature to do something because if not, we're going to see these effects that are going to be happening on a wide scale. But we're also going to see the people who are the most marginalized facing those evictions really being the people who are going to pay the cost, right? If the legislature doesn't do something about that, right? They're going to be pushed out of their homes and they're going to be homeless, right? Or, I guess best case scenario, displaced, right? Next slide. Thank you. But what people don't really, not everyone knows about the eviction process is the fact that evictions in court are about a very, very specific thing, right? Evictions are about possession of the unit, right? As it says here on the slide, eviction process is not a debt collection tool. When the landlord files an eviction proceeding against the tenant, yes, they're saying the tenant owes me money, but what they're really saying is the tenant owes me money, and that's why I need that unit back so I can rent it to somebody else who can pay me, right? I'm done with this tenant, right? That's basically what the landlord is saying. But the process that exists, it doesn't actually give the landlord the money, okay? It's not like at the end of the eviction, if the landlord wins, all of a sudden the tenant has to, it's gonna write out the check or give a money order paying all the back rent. And it also means I have a lot of tenants who will ask things like, well, can I get can I get the rent reduced? Or what if I have, I have this problem with the landlord, he's been harassing me. And I tell them, well, that only comes in if it's related to the eviction proceeding, to the notice that you got, right? So in most of the cases that we're going to be seeing, it's going to be non-payment of rent cases. So the landlord harassment only comes into play if they're talking if it's related to the non-payment, which is, it might not be. So none of that evidence might come in. And even if there are bad conditions, the landlord, the jury may have the right, may have the opportunity to lower the rent. But if the tenant, let's say the tenant loses because the tenant did fail to, didn't pay the rent on time. The judge doesn't have the power to say, yes, tenant, you can stay and just pay the back rent, right? So if we don't do anything about this issue, what's going to happen is that all these tenants who were not able to pay the rent during, the crisis are going to be evicted. They're going to be homeless, and the judgment, the amount of unpaid rent is still going to be, left on the table. There's still going to be a judgment that the landlord then has to use other means to collect on, right? It's like very standard, because what the eviction process does is it will just produce a judgment at the end of it, saying, okay, the tenant owes $2,000. Now the landlord has to go and collect it, right? So what AB 1436 does is that it allows the tenant to remain in their home, and it allows for the landlord to continue to, pursue the rent that's unowed, just in all the traditional ways that they normally do. Because another aspect of the eviction process is that the eviction process is something called an expedited proceeding, which means that it has a special place in the court system where it sort of gets to jump the line, right? So most cases you file a lawsuit and it can take, a year, months to finally go to court. But in eviction, once the landlord files and they make a request for a trial date, the court has to give them a trial date within 20 days. And so the eviction process is very, very fast. And if we don't do something about that, we're going to see just homelessness, but this amount of unpaid rent is going to just continue to accumulate. And we're going to see deepening debt. We're going to see people homeless, and we're going to see eviction records, right? And people are not going to be able to rent new places with this eviction record, with this eviction on their record. In fact, I just had a case with a tenant where they were not able to pay they were evicted 7 years ago, and they were finally trying to move out on their own. They've been living with their parents, and they came to us for help because they said, what can I do about this? I can't find a place to rent because of this eviction that happened 7 years ago. And the debt that they had, the unpaid rent, had continued to accumulate interest. So it creates a really, really serious problem that's going to have impacts that are just going to continue to affect families for, possibly decades, right? So that's my bit on the eviction process, and I'll hand it back over to Sasha.
Thanks, Natalie. So yeah, we know that eviction is not the answer here, right? Eviction is not going to make it more likely that people can pay off that judgment for the back rent. It's not going to make it more likely or faster for our state to recover from all of the impacts of COVID. And it's definitely not going to help people protect themselves from exposure when we know that your home is the #1 protection against the pandemic that we're experiencing right now. So we feel that the answer for the unpaid rent issue, for protecting tenants from this wave of evictions, is AB 1436. And I'll just this is by no means sort of an exhaustive analysis of the bill. I'm just going to give some sort of top lines. I know that Housing Now has a lot of resources, a lot of materials. If you need more information to get ready for a lobby visit, I think all of that will be made available. But I did just want to go over some sort of basic talking points for when you're having these meetings about this bill. So I'm kind of going to talk about both what it does and what it doesn't do. And there's really 3 big points to make on what the bill does. The bill removes eviction as an avenue for the landlord to collect the unpaid rent for that back rent that went unpaid during the COVID pandemic. And the bill describes that as either 90 days after the declaration of emergency ends, which right now it's still in effect, or April 1st of next year. A lot of the pushback on this bill was people being uncomfortable with, and by people I mean legislators, being uncomfortable with sort of the open-ended nature of how the bill started out. So there is that bookend of April 1st to deal with that concern. So the bill says that a landlord cannot evict a person for not paying their rent during that time period if they certify that they've lost income due to COVID. And that is not something that requires like detailed documentation or anything like that. It's just a statement from the tenant, I've lost income during this pandemic. So what happens to that rent? For 1 year after that period, a landlord cannot pursue court collection of that debt. That year-long period is really a chance for the tenants to catch up, to help them get back onto their feet and be able to pay off the back rent or to reach a voluntary agreement with their landlord. And that agreement could last much longer, right? It could be a payment plan that sort of works for everybody. The bill does contain...
Sasha, could you ask everyone to mute? There's someone making a lot of noise.
Yes, in fact,
it's a little distracting.
Thank you. If everyone could mute, that would be great. And I'm going to mute everybody. Okay. So as I was saying, the bill gives this 12-month repayment period where the tenant can make an arrangement with the landlord. If they win the lottery, I guess they could just pay off all of the back rent. But this is really to encourage voluntary agreements that kind of work for everybody. The bill has some limitations on what can be agreed to. We know that sometimes, most times, there's a power imbalance between the landlord and the tenant. And so the bill says things like you can't agree to pay back more than you owe because we don't want this to become an abusive situation. And then the bill also says that landlords, once that 1 year period has passed, they can still use other tools like small claims court, like a civil action in court to try to collect the back rent, but they cannot evict a person and push them out of their home. What that means is they can still get that same judgment that Natalie was talking about, that they would get in eviction court that says, tenant, you have to pay landlord this amount of back rent. What they can't get is the second part of that eviction judgment that says, and you have to get out of your home. Importantly, a landlord would need to basically offset the back rent by any financial assistance they receive, right? We don't want landlords double dipping if they're going to get money from the state or from the federal government, or if they're going to get some local help or some mortgage relief from their bank. We want that to be accounted for, and we want the tenant to sort of share in that benefit, recognizing this is a situation that we're all in. You will get these questions from staffers if you're doing a lot of lobby visits on this bill. And so just wanted to really clearly state what this bill doesn't do. This is not about free rent. The bill does not alter the obligation of the tenant to pay their rent, and it doesn't change the law for their rent going forward after the pandemic. So that means tenants are still on the hook. The bill does have some protections in terms of the effects of that debt on their credit, on their ability to rent housing in the future, but it still allows the landlord to reach an agreement or to pursue that back rent. And so you might get questions about whether this is, a cancel rent bill. It does not go that far. It's a really important step to hopefully get there. And it's a really important sort of initial protection that we can do for tenants right now, but this is not canceling rent. The bill also doesn't create some sort of radical new regime or process for dealing with rent. I like to mention that because there are situations right now where a landlord might try to file an eviction for unpaid rent, and the exact things that this bill says would happen to that case. So if a landlord is trying to collect rent that's more than a year old, for example, they would have to go through these other civil actions. Even under current law, they can't evict somebody for that. And so this is just treating COVID rent the exact same way. This is kind of detailed and maybe came out a little bit small. these are some potential questions that may come up. There's a related bill, which is Senate Bill 1410. You may get asked about that bill. The most important thing to know about that bill is it's really a bill for landlords. It's an important piece of the puzzle. It provides some assistance for struggling landlords through a tax credit provided by the state. It's kind of a complicated thing. But the important thing to know, even though that bill has some pieces that talk about evictions, it is not a sufficient protection to prevent this wave of mass displacement and homelessness that we're looking at. You might get asked about local protections. You know, in some jurisdictions, in some cities, we have local eviction moratoriums and things like that. And so people will say, well, isn't that enough? Why do we still have this problem? And the answer to that is those are mostly temporary in nature. They just pause these evictions, but they don't stop this wave. And a lot of people in California, most people in California, are not in a jurisdiction that has any protections at all. There's the Judicial Council rule that I've mentioned already a couple of times. Similar to the local protections, that just pauses the eviction process, but it doesn't create any new defenses for tenants. It doesn't change whether their landlord has to take the back rent, even if they can come up with it. And the Judicial Council has announced a couple times, including today, that they are trying to repeal that rule. So we could see that rule disappear as early as the middle of August, according to what they announced today. So this bill is what can be put into its place to make sure that people are protected. Legislators love to ask you, what about the mom and pops? What about those small landlords who may not be a giant corporation? This might be, you know, one rental property they own to support their retirement. I think the way to respond to those kinds of questions, you'll get asked, does this exempt small buildings or single family homes? And the answer is that it does not. And the reason for that is, you know, there's no reason that a tenant, just based on having a small versus a big landlord, and they may not even know that, should get different protections than anyone else. This is about avoiding a massive crisis and a lot of pain for very vulnerable people. And so we should be protecting everybody the same. And the state should work, you know, to address the specific challenges of those smaller landlords who may be at greater risk of losing their properties through things like that other bill, SB 1410, that can provide some assistance to them. That doesn't mean that we don't help their tenants. There's also a question that's been coming up a lot around, well, what if somebody can pay the rent, but now that we've passed this bill, they're not able to? There's a couple responses to that. One, the bill does require people to certify that they have lost income under COVID. And, you know, we think that that is sufficient to guard against this perceived problem of people sort of cheating. The other thing is that we're seeing tenants already find ways, even though they can't afford it, we're seeing them find ways to pay their as much rent as they can. We're even seeing people moving out of their homes, knowing that they're not going to be able to pay the rent and there is no current protection in place. So really that is a concern that is kind of overblown and I don't think is a real one. So that's pretty much all we had prepared. I just wanted to reiterate some sort of closing thoughts. You know, be confident in these meetings. You know your story, whether you are a tenant, whether you are an advocate. If you're a tenant, you know exactly what you're facing. You know what housing means to you. If you are an attorney or an advocate, you know how many people are coming to you for help. You know those client stories. You know those community stories. And that is our power in these meetings, is really looking people in the eye, hopefully, if they turn on their camera on Zoom, and really presenting them with the lived experience of the people that they have the duty to protect and to represent. So be direct, because you know you have the absolute right to be there. Your legislator works for you. And if you have questions, if you need help preparing, if you need somebody to join you for a lobby visit, please reach out to us. We're here to do that. We're here to help you. And that's everything that I wanted to say. So I will figure out, I believe you can unmute yourself if you have questions. I think I did this correctly. So please feel free to jump in. And thank you.
Thank you. John Castelfranco from the Davis United Methodist Church. And I'm wondering, just for the current legislative session, how many weeks do we have in which we need to meet with our legislators around 1436? What does the timeline look like now?
So that's an excellent question, and I totally should have put that information in this presentation. It's a little bit hard to know, and I'm not being cagey, it's just that things have been changing multiple times a day because of the pandemic. There have been some committee schedules that have been shifted around and keep changing because there have been some legislators and some staff that have tested positive, and that has sort of thrown things into chaos in the Capitol. What we know is that this bill will be heard, its first hearing will be in the Senate Judiciary Committee as early as next week. That will be sort of the first vote that happens on this bill as it's written now. And so there are multiple points where votes are taken. There's usually what's called a policy committee. As I mentioned, this one will be in the Judiciary Committee because it deals with sort of court processes. And if it passes that vote, so there's a group of senators that are members of that committee, and they are sort of our most key immediate targets because we need it to pass that committee to keep moving through the process. Once that happens, once we make that happen by lobbying all of them, then the bill can come up for what's called a floor vote, where in this case, the Senate will vote on it as an entire body. And all of these things sort of get scheduled once the last thing happens. So what will happen after that, assuming it passes in the Senate, is it will go back to the Assembly for more votes. The key thing to know is that that entire process is likely to wrap up. You know, we want this bill to pass as quickly as possible, but by about September, that's basically the window that we're looking at in terms of this bill passing in the legislature. And then it has one more step, which is getting signed by the governor. And that, you know, he has some time to sign bills once they pass, but the sort of deadline for him to pass bills, I believe, is mid-October. I don't have the exact dates up in front of me. Sorry, I've said a lot, but one more thing that I'll say is that there might be a possibility that this bill, if we do a really good job on all of our lobbying, if we sort of convince the whole legislature that this is something we need, they may actually have some faster ways of getting it in place through the budget process. And that's why we also need to be putting a lot of pressure right now on the governor, because he has a lot of control over that process and whether or not that happens. If we're super successful and we're able to convince him and our leaders that that is what's needed, the bill could actually go into effect right away. And so if we win all of that, we might have this bill in place as early as sort of the end of August.
Thank you.
And then I think Hector had a question or raised his hand.
Yeah. Hi, Sasha. Thank you so much, and everyone, for the great overview. I had a question. It's kind of tied into 1410 and also the conversation around mom and pop landlords. Have you seen or heard of anyone referencing mom and pop landlords with an actual figure of what percentage of landlords are quote unquote mom and pop landlords, and sort of where that argument kind of what data it uses as its foundation?
So I was smiling because Oop, I just heard a big echo. Okay, I think it's gone. I'm smiling because I think if you talk to the apartment associations, they will tell you that 150% of landlords are mom and pops. They're all, you know, retired. They're all your grandmother, and we need to protect them at all costs. I think there are varying figures on how many small property owners there actually are. I don't have a good answer to that question, but I think the vast majority of membership of at least the sort of really big statewide apartment associations, meaning the California Apartment Association, the California Association of Realtors, those tend to be sort of the big players in the Capitol and who lobby members regularly on these bills. The majority of their membership, as far as I know, are larger landlords, have maybe 10 units. Yeah.
Great. And is just as a follow-up, is there actually, I haven't really been able to find anything, but is there an actual definition for mom and pop landlords in terms of how many properties there is owned? Is it like 1 to 2, 3 to 4?
No, not really. I sometimes hear kind of 1 to 4 when I'm talking to legislators as what they sort of consider to be a small landlord. But there is no official definition, which I think the apartment folks use to great end to say everybody's a mom and pop.
Okay, thank you.
Actually, Sasha, it depends on the jurisdiction. LA has a definition, Santa Monica has a definition, West Hollywood has a definition, and I'm sure most of the local jurisdictions that have rent control have a definition because special rules get set up for mom and pops, so they have to define them. But those definitions are very different in each jurisdiction.
That's a good point.
I have a question. One of the issues that we've had with 1436 is that it's a gut and amend bill. And so in spite of all of our efforts to make sure that staff knows ahead of time that we're not talking about the CalWorks bill from last year, we're talking about the COVID-19 rent relief bill from this year. When we get on the calls, a lot of them are still on CalWorks, or they're telling our callers, oh, we already voted yes for that, when in fact they haven't even considered this. Why is this a gut and amend bill? What's the advantage of doing that? How could we have avoided this confusion? And how can we avoid the confusion now that we're in crisis mode and we cannot afford to have a staffer not be prepared to meet with us? We need them prepared and ready to say yes. And if it's not yes, why not? What do we need to do to move you?
Yeah, those are great questions. I'll take them sort of in reverse order. One thought that I have in terms of just making sure that the staffer is actually doing their homework, is preparing for the meetings, that it's the right staffer, because as I mentioned, you know, different staff may get assigned to different issues and different committees. I would include in your meeting request, I would include that, you know, this is a housing bill that's going to the Judiciary Committee, that it has been changed from what it was before. What Elena's talking about when she says gut and amend is that this used to be a different bill. And the reason that so what gut and amend means is sometimes a legislator will literally take a bill that they have, delete everything in it, and add a whole different bill into it. A lot of times that is because they realize they need to do something about an issue and we've passed the deadline for introducing new bills. This year, things were completely bananas in terms of the process for introducing legislation. Because of COVID, a lot of members were basically told, you don't get to introduce new bills, and you have to cut, you know, you have to basically drop like half of your bills. And so I honestly can't remember specifically what the issue was, but we knew that that certain sort of powerful leaders were not going to let new bills get introduced in sort of the beginning of the process, meaning assembly bills being introduced in the assembly. And so what was done with this bill, it had already made it to the Senate, and so those people didn't have the ability to hold it back. That's why all of the language that's in the bill now was put into what we call vehicle, this bill number. So it was basically because things are moving fast and furious, and COVID has sort of disrupted the whole process. And we wanted to be sure that we weren't subject to sort of the whim of one legislator who might have the power to hold it back. So that's why it is an assembly bill in the Senate that hasn't been voted on. That's kind of an unusual situation to be in. And so I would just be sort of diligent in pointing that out when you make the initial ask, and ask to be meeting with the person who's assigned to the Judiciary Committee. I think that'll help a lot. Natalie?
You mentioned before that one thing that helps is doing your homework and finding out which staffer we need to talk to. How do you find out which staffer has been assigned to what?
So all I meant was find out who you are meeting with and figure out, you know, are they somebody who works in the district office? Are they somebody who works, you know, who is assigned to that bill? Or is it just that sometimes it is the case that there's a million meetings in a day, or there's a lot going on, and so you sort of end up meeting with somebody else who can pass your information along. The reason I think it's really important to just capture that information is so that we can then circle back with the person who is assigned to it, and make sure that we've gotten their vote or their recommendation to vote yes.
Okay, so you might find that out like in the meeting, or you might find that out in the emails prior, like as you're arranging the meeting.
Exactly, yeah.
Is it appropriate to start by asking, can we please meet with the legislative director or the person who does housing related bills? So, because I've been doing that, but we're getting assigned a lot to someone in the district office who really doesn't know anything. So at what point do you say, this is an emergency, we really need to talk to someone who knows something about the bill?
I think it's fine to say that up front. I might phrase it a little bit differently. I might say, you know, this bill is coming up for a hearing very soon, and it would be really great if we can talk to, you know, it's perfectly fine to say we want to meet with the legislator themselves. If you know, and if you get a no, I would say, you know, this bill is coming up immediately. It's a critical issue. You know, we'd like to talk to the person who is assigned to the bill. And even that information, I would add, like, if you still get pushback at that point, that can indicate something useful in terms of, you know, are they dodging you? If they are, we can sort of take a different tack with that kind of an office, and find other ways to put pressure, or have, you know, other people come in and reinforce our ask for a meeting, to really send the signal that we're not going away and that this matters. And I know we're a couple minutes over time already. Are there any other questions?
I have one more question. So we were on a lobby visit together, and I used to actually do this when I was at Legal Aid, mainly on the federal level. It's a little bit more formal with the feds. So any feedback on the visit that we did? It was with Senator Umberg himself. He hadn't read the bill. We and then I got sort of jovially pushy, I would say. Did I overstep? Was it fine? He was smiling through it. Any feedback on that?
No, I think it was fine. Humor can help a lot. And, you know, part of it is just reading the room and reading the person that you're talking to. I think he was clearly very comfortable. He was totally fine with getting pushed a little bit. He's a seasoned legislator. He actually, I believe he spent a long time in the legislature and left and has now come back. So he's used to these things. He's been around for a long time, and I think has, you know, sort of a thick skin, and he can take it. Others, you might see them start getting visibly angry or something. It's always just important to sort of tailor it to the meeting that you're having, but also be yourself. You know, this is important, and I think it's totally appropriate to be conveying that to people. And if that means we have to get pushy sometimes and not let them, you know, get away with not answering a question or not saying how they're going to vote, you know, we can address that in other ways. If that means we send in a different person the next time, that's okay. Because I think that all of that helps reinforce the message that, you know, we're here because we care about people that they should care about too.
Yeah, he was smiling back. I was joking with him. It seemed to be going just fine, but I just thought I'd ask you.
Yeah, no, I got the sense that he actually was having fun. And that's good, right? We want people to be enjoying these meetings. We want them to be interested, and we want them to view us as a resource. So I think I put that in here somewhere, but you know, it's okay to just offer ourselves also as people who know about evictions and know what tenants are going through, and to tell the people that, you know, if you ever have a question about a housing bill and you're not sure about it, you know, we're happy to serve as that source of information. All right, well, with that, I think I'm going to figure out how to stop recording. And I think we'll leave it there. Thank you so much, everybody, for your time.
I'm going to put the tenant survival guide on if people want to get a copy of it. It's mainly written for advocates, but it does explain all of the current laws. And it does it from LA biased, but it's useful anywhere in the state.
Great. Thank you, Elena. All right. Well, take care, everyone. Go get those meetings scheduled. And like I said, please reach out if you need help, if you have questions, if you want to prepare. Please view us as a resource as well.
Okay. Thank